Hello everyone. I trust you all doing well and safe and healthy. I welcome all the attendees in this fifth very insightful webinar on the concept of bail is rule and jail is exception by Visual Law Associates, a law firm provided litigation and ADR services. When we talk about today's topic, I must pay my respect and tribute late Honorable Justice Krishna Iyer, who has many land-breaking verdicts to his name, and one of the most relevant among them is State of Rajasthan versus Balchand, which is pronounced in 1977. While pronouncing this landmark verdict, the justice relied upon many rights guaranteed to the accused by a supreme law of land, the Constitution of India. And most prominent among them is fundamental right to liberty guaranteed under Article 21 of Constitution. Today we have with us our keynote speaker, Prof.Dr.B.T Kaul, advocate, former Chairperson, Delhi Judicial Academy, and Professor, Delhi University. I wish to give him a brief introduction of Sir. Dr. Professor B.T Kaul has obtained his LLM and PhD degrees in law from Delhi University. He was a Foreign and Commonwealth Fellow at London School of Economic and Political Science, and from where he earned second LLM degree specializing in intellectual property law and comparative and international labor law. Professor B.T Kaul has teaching experiences in the field of law of more than 4 decades. In February 2014, he was invited by Honorable High Court of Delhi to head Delhi Judicial Academy as its chairperson. Prior to this, he was a professor of law and professor in charge Law Center 2, Faculty of Law, Delhi University. As chairperson Delhi Judicial Academy, he gave new inputs to judicial education and training programs at Delhi Judicial Academy by improving their quality and increasing the number of programs for judges and other stakeholders. He was a member of expert committee set up by Ministry of Home Affairs, Government of India in 2008 to examine suggestions made by department relating Parliamentary Standing Committee on Home Affairs in its 120th report on Code of Criminal Procedure Amendment Bill 2006. So far as they are related to summon and warrant cases and summary trial procedure. In 2014, he was nominee of Chancellor, National Law University, Odisha. It is indeed a privilege for us to have with us Professor Dr. B.T Kaul. I welcome you, sir, and over to you.
These fundamental rights has over the period of time gone much beyond what it used to be before Maneka Gandhi's case. Maneka Gandhi's case was a watershed in the development of the rights jurisprudence in this country. It was this case which did away with the A.K. Gopalan doctrine, which only said about the procedure established by law. As long as there was a law, it was enough. And it prescribed procedure, it was enough. But Maneka Gandhi's case was where the court said no, the law must be just, fair and reasonable, so must the procedure be right, fair and reasonable. Now this expansive interpretation of Article 21 led to the development of umbrella of rights, and among them many of the rights of the arrested person and accused, to which I will tell in due course of time, but I just want to take up a broader picture before I go to law of bails. Now, you know that we have a very, very important article, Article 20, which has 3 parts. One, that a criminal law which is made will always have a prospective effect. It can never be made retrospective. You cannot retrospectively enhance the punishment of an provision or an offense. Second is that there cannot be a double jeopardy. And third is very important right, which we should always talk about, is the right to silence. I think all of you know this Nandini Satpathi's case, I think is a very, very important case, which all of us at some point of time need to read this case, because it is a elaborate case which brings a distinction between American law and Indian law on the question of right of self-incrimination. And Nandini Satpathi's case, Supreme Court said, yes, right against silence is there, but it is not an absolute right. You have a right not to answer the questions or interrogatories which are incriminating or have the potentiality of incriminating you. But if a question that is asked to you has no potentiality of incriminating you, you cannot refuse to answer that. Now, this will become important in the course of things when we develop the law on bails, because you'll find that one of the areas where police generally tell the court that this man is not cooperating because in interrogation he's not cooperating. And I think the language of the police is that cooperation means that he should confess, and he is right not to confess. That is what Article 23 says. And the Supreme Court in one of the cases has said that right not to confess is not amounting to non-cooperation. Now that's something which will flow from this article itself. Then we have Article 21, life and personal liberty. Life of a person and personal liberty, and that is where the balance has to be struck. When we go to law bails, we will see the on the one hand the societal interest, on the other hand the personal liberty of a person have to be reconciled. These are two conflicting claims, but how the courts reconcile these two conflicting claims in the light of the law that has been laid down by the Supreme Court, and the reconciliation is brought by the Supreme Court in various cases that we will look at. So the point that we are trying to make is that you can be deprived of your right to life and personal liberty only with the law which is reasonable, just, and fair. And if the law is not reasonable, just, and fair, I think one of the cases which all of you must must know at uh, Nikesh Tarachand versus Union of India, which is a case of 2017, which dealt with Section 45(1) of the PMLLA Act, and the court found those conditions uh, were unreasonable, were violative of Article 14, were violative of Article 21, and therefore struck them down. And the law on the grant of bails became slightly liberal after Nikesh Tarachand's case, because it was found to be violative of Article, that provision itself, which uh, was saying that what are the standards of proof that has to be seen, or satisfaction of the court that has to be seen relating to the conditions, two conditions that were imposed by 45(1), whether a person should be granted bail or not. But those are questions which will come at later stage. But at the same time, we must also look at Article 22, which is very, very important, which says any person who is arrested must be informed about the grounds of arrest, and also that he has to be produced before the magistrate within 24 hours, excluding the time that is taken in undertaking the journey. Now, you must understand that production of a person before the magistrate is a fundamental right. Right to be informed about the grounds of arrest is a fundamental right. It's not only under the CRPC, we have 5057 that we will talk about the legal rights. No, we're talking about the fundamental right under Article 22 of the Constitution. Now, there is no fundamental right of presumption of innocence, but there is a human right, and that is what Supreme Court has in Ranjit Singh versus State of Maharashtra held that right of presumption of innocence, and whole criminal jurisprudence, the whole edifice of criminal jurisprudence is based upon presumption of innocence of a person till he is proved guilty beyond reasonable doubt. And that is a very important consideration when we go to law of bails, except for two provisions in the Evidence Act when we deal with the general criminal law of India. That is the two presumptions that are created under Section 113A and 113B. That is with respect to presumption as to the abetment to commit suicide, and bride burning, uh, dowry death. Those are two cases where if certain conditions are satisfied, the presumption of innocence is dispelled and there is no more presumption of innocence. But generally speaking, in the IPC scheme, we find with respect to most of the offenses, the presumption of innocence is a cardinal principles, and that is a very important principle that we will find courts applying when we draw a question of grant or refusal of a bail. Now, having said that, that person has a right to be informed of the grounds of arrest. Now, once he is arrested, there are first question that should arise in your mind is if it is a case whether it is a bailable offense or it is a non-bailable offense. When the police officer informs you about the grounds of arrest, he has also to inform you if it is a bailable offense that you have a right to bail under section 436. Now in 436, we have right to bail as a matter of right provided you are ready to give bail, you are ready to give sureties about and security of the amount that is asked by either the police officer or by the court before whom you are produced. Now that has to be reasonable, that has to be not to the extent that it will amount to denial of bail. And I think if you have looked at an amendment that has been made in 436, because first we must understand when we go to that amendment, first we must understand what is the definition of bail that we are going to talk about. And I think you must look at that bail has not been defined in the IPC. Therefore, what is talked about is a bailable offense, and what is talked about is a non-bailable offense. Now, in the scheme of the IPC, we have, if you look at the schedule to the Criminal Procedure Code, uh, all offenses in the IPC are brought down in that, and each offense is classified as bailable or non-bailable without telling us as to what is the criteria that the legislature has taken into account while uh, deciding a case is a bailable or non-bailable. I think we generally see that offenses which are punishable with less than 3 years are considered to be bailable offenses and other cases. But then there are exceptions on both sides which we can look at. But the first question therefore comes, what is a bail? Now, you must first understand that what is the effect of an arrest? The effect of the arrest is the deprivation of the personal liberty. Effect of the arrest is that your liberty, your personal liberty is now being impinged. There's an inroad made. You cannot move the way you would like to move. You cannot go to the office. You cannot join the family. So many of the rights of the person get restricted. So what is the purpose being served by bail? Now the question that we have to see is, why should a person be arrested in the first place? Now once a person is arrested of an offense, now if it is a cognizable offense, uh, we have arrest has to be first preceded by filing a complaint with the police. Police does not have any complaint is made to the police officer. If that complaint has a duty, legal duty to register the FIR. Now, once is what is the necessary consequence. Now, investigation is that it may be necessary for the purposes of ensuring that the person is available for investigation and then if he is put on trial, he is available to stand the trial, and if he is finally convicted, he is available to undergo punishment. Therefore, arrest is not a punishment. Arrest is only to ensure presence of the person for the purposes of investigation, for the purposes of trial, for the purposes of ultimately undergoing the punishment if he is found guilty. If these things can be ensured, then we say bail is the rule. Refusal of grant of bail is an exception. That is why presence before the police officer can be ensured. If the presence of the person before the court can be ensured, if the presence of the person to undergo punishment can be ensured, it is always better to leave the person to enjoy his liberties, because there is a presumption of innocence. And if there is a presumption of innocence, unless he is proved to be guilty, his personal liberty cannot be deprived. So that's where we say. But the question that you have always to keep in mind is, once an FIR is registered, if it is a serious offense, there are too many questions that can arise in the mind of the investigating officer. One, if it is a very serious offense, the person may, uh, you know, try to flee, run away. Second, there is an apprehension that the person may tamper with the evidence, may destroy the evidence. There's a chance that if he, is able to uh, repeat his offense, so therefore, the more the serious the offense, the more the chances are that a person may abuse his liberty, and that is why we say, what is the meaning of bail? Now, bail is not defined, as I said, but bail is primarily defined in law lexicon, and which has been defined, and this is very important. Bail is defined as security for the appearance of the accused person, on giving which he is released pending trial or investigation. Now, you have to ensure, by way of a security, that you will be available for investigation, you will face trial, and if that can happen, then what happens is, from the custody, legal custody, you are to be given in the custody of the surety, and it is the duty of the surety uh, uh, to ensure that you are available, or you are participating in the investigation as and when it is you are required to undergo come for investigation or face trial. And if a person is not able to exercise that control over him, he can go to the court and say, kindly discharge me. I am not able to control this person, because once a person is taken as a surety, his bona fides are verified, the surety amount is ensured that he is solvent, he is a solvent person, and he will be, in the event the person defaults, he'll be able to pay the amount. So that is where we say it is a security that is given for the appearance of the accused person, on giving which he is released pending trial or investigation. Uh, what is contemplated by the bail is to procure the release of a person from legal custody by undertaking that he will appear at the time and place designated and submit himself to the jurisdiction and judgment of the court. And if you look at Form 45, you'll find all this is already a prepared form, which is a bond, which is a surety. The name of the person is entered there, and amount is entered there. All those things you'll find it's already stated in that form itself. And the question was, in Motiram's case, I think all of you must have gone through that case, and a very, very important case. And why I am taking this case, because 436 has been amended by 2005 amendment, and that amendment has element of what court decided in Motiram's case. Now, in Motiram's case, the Supreme Court said bail covers, now this is very important, which you must kindly take note of. Bail covers both release on one's own bond with or without sureties. Because you'll find a lot of debate, lot of discussion, lot of research undertaken by Justice Krishna Iyer, who tried to prove the point that bail necessarily does not require a surety. It's not necessarily, because that was a case of a person who was alleged to have committed an offense of theft, and he had been asked by the magistrate, because court had granted him bail to the satisfaction of the magistrate, and the magistrate had put 10,000 rupees, and he had said the surety should be a local surety. He had refused to accept his brother, who was a, a resident of another state, and therefore he had refused to accept him as a surety. Now, therefore, the court said, can't he be released on his personal bond? And the decision in that case was, yes, bail covers person's release on one's own bond with or without sureties. Now, if you look at 436, which has been amended in 2005, you find the uh, words that have been used in 436 is very clearly stating to this effect. I'm reading the first proviso, I need not read everything, but I think it says, provided that such officer or court, if it or it thinks fit, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail from such person, discharge him on his executing a bond without sureties for his appearance as hereinafter provided. Now, therefore, if you go further down to the explanation, when a person is unable to give bail within a week from the date of his arrest, it shall be sufficient ground for an officer or the court to presume that he is an indigent person for the purpose of this proviso. Therefore, the person can be released on his personal bond without a surety also. That is what is talked about in 436. Now, I would also like you to take same view you must can also is reflected in 436A. Now 436A I will come later on, but I would just like to take you to one simple reason that has been given in the end. He shall be released by the court. Now this is a case of people who have been languishing in jail for one reason or other reason and have spent more than 50 one half of the sentence if awarded to them, if it had been awarded to them, maximum sentence that it would have been awarded to them, if they have spent that amount time in the jail as an under trial, then it says he shall be released by the court on his personal bond with or without sureties. Now, this is what I just wanted to emphasize, that this country is a country of poor people. Who are the people who go before the courts, who are brought before the courts, are the poor people who are not people of means, may not be. And look at the fate of the migrant workers who come all the way from different parts of the country, and suppose they have to be released on bail and they do not have a surety, they do not have a security, any other person who can give a security on their behalf, surety who would be a surety on their behalf. So therefore, those are the cases which Moti Ram's case wanted to be covered, and not dependent upon whether he finds a surety in the place where the offense has been committed or where the local Alaka magistrate is exercising this jurisdiction. Now, these are two aspects that I just wanted to take at this stage. Now, I said law bails essentially is a balancing. And I'm sure those of you who have read Zahira Sheikh talks about conflicting interests, that is the interest of the accused, interest of the victim, interest of the society, or rights of the victim, rights of the accused, and rights of the society. But earlier, the people would say it's a dogtail of two conflicting demands, namely, on the one hand, the requirement of the society from being shielded from the hazard of being exposed to the misadventures of the person alleged to have committed a crime, and on the other, the fundamental canon of criminal jurisprudence, the presumption of innocence of an accused till he is found guilty. Now that is where the court's judicial discretion in especially cases which are non-bailable offenses, how do they exercise? This is what you find this conflicting interest talked about in Sanjay Chandra's case, which today is considered to be one of the leading judgments on the question of exercise of the discretion and the factors that the courts have to take into account while dealing with serious cases in respect of the offenses which are non-bailable offenses. We'll come to this case at a later stage, but this is just one basic point that I just wanted to say. First, I said what is a bail, what are the conflicting interests when the court has to balance them, and how the court exercises its jurisdiction in such cases, and how it exercises judicial mind in such cases is very important for us to understand. 2-3 things I just wanted to quickly deal with it. Who puts the criminal justice system into motion? Generally, it is the complainant. How does he put it into motion? By registering an FIR. Once an FIR is registered, it uh, role of the investigator starts. Role of the investigator starts for investigating the offense, which may also involve not only recording of statements, uh, recovering collection of documentary evidence, forensic evidence. It may also involve in non-bailable offenses, arrest of a person. And this, how do we deal with registration of FIR? I said Lalita Kumari was the Supreme Court has dealt with very elaborately 5 judges bench, which talks about it is a legal duty of the police. They have no discretion. Wherever there's a prima facie cognizable offense made out, they have to register the FIR. Then I said 156.3 is also one of the modes in which we should also, if the police does not register, magistrate can direct them to investigate. They cannot investigate. They will register the FIR. We have a Sakiri Vasu judgment 2008. And we have a recent judgment of the Supreme Court, Priya Srivastava versus State of UP 2015, 6 SCC 285, where Supreme Court says 156.3 should not be allowed to be misused by the magistracy. They must be vigilant. They must be diligent in ordering 156, exercising powers under 156.3. Now, this is, am I audible? Hello?
Yes, sir. You are audible, sir.
Okay. Now,
Audible, sir.
I was only trying to say, how does the criminal justice system come into motion? Registration of an FIR leads to investigation. Investigation also involves, can include arrest of the accused, and arrest of the accused, there are 24 hours he has to be produced before the magistrate. Either the magistrate will discharge him, or the magistrate will grant him bail if a bail application is moved, or the magistrate will send him to the police custody if there's an application and he is satisfied that custodial is that police does not have the power to grant bail. Now, it is one thing that you have the power, but you do not exercise it. Now, anybody who wants to look at it, if you look at 437.4, 437.4 would not have been there. You see, it says an officer or a court releasing a person on bail under subsection 1 or subsection 2. Now, mark the words of section 437.4. It says officer or court releasing a person on bail shall record in writing his or its special reasons for doing so. But then, when we go to 437.5, 437.5, which talks about cancellation of bail, it says only court. So therefore, police does not have the power to cancel the bail, but magistrate has the power to cancel the bail. But on the question of grant of bail, I think I need not delve on that, because let us go back to these are the powers of the magistrate and how these powers have to be exercised. We have a lot of cases, and I think the cases that we should look at when we deal with 437 and 439, I think at the moment we have a very good judgment of the Supreme Court, that is Sanjay Chandra, that should be looked at, how these powers are to be exercised, various factors that the courts have laid down, which are not exhaustive in themselves, but those are only catalogs of the factors like enormity of the charge, chances of the person jumping the bail, chances of the person tampering with the evidence, influencing the witnesses, chances of the person, now those are factors which have to be in each case to be taken into account while the court, if it is a magistrate's court, or the high court exercising the powers, exercise it in the light of the all revisited by the Supreme Court when it went to the Sanjay Chandra's case in 2012. Of course, there was earlier also a good case, Gurcharan Singh versus State of Delhi. That was also one of the cases which I think is a good case which can be taken care of, which will take care of 437, 439. Now, I just want to take a very important area which is bothering a lot of people, and that is the area of 167. Now, 167, I just wanted to spend some time on that because that is something which all of you must be looking at and expecting me to cover that case. If you look at now, once a person is arrested, police is expected to complete its investigation in 24 hours. 24 hours is the power, is the right given to them under the law. Beyond that, when they have to get either the police custody, or they have to get the judicial custody, or the person has to be sent to the judicial custody, it is a power which vests with the magistrate in 167. The police remand cannot be for more than first 15 days. That does not mean all the 15 days. That means whenever the police remand is to be taken, it must be taken within the first 15 days. Then rest beyond 15 days, that any custody that is taken will be judicial custody. There is no time limit in which you must finish the investigation, but then there is a pressure build up under 167 2, that if it is an offense punishable with death, life imprisonment, or minimum of 10 years, then the police report, that is charge sheet, must be filed within 90 days. And if it is an offense which is punishable with less than 10 years, or 10 years or less than 10 years, up to 10 years, then in that case it is 60 days. And if the police fail to submit the police report, what we call as charge sheet, then by virtue of this provision, the person becomes entitled, which is an indefeasible right. He becomes entitled to bail, what we call as a default bail, irrespective of what the merit of the case is, irrespective of the fact what the punishment it will entail. So this is very, very important aspect. I think, you have certainly to keep in mind, and there is a judgment, two judgments which I want to rely upon and which I want you to look at. And these are very beautiful judgments, which are proactive judgments of the Supreme Court. If you fail sheet within the statutory period, the person can move an application for grant of a default bail, and it does not matter that after that if you file and the application is still pending. Now earlier what used to happen is when a default bail application is filed, the magistrate would keep that pending or will not decide. By that time they would file the charge sheet, and then they would say that now that the charge sheet has been filed, your indefeasible right has become infractuous. I think the very good judgment that you have to look at is Rakesh Kumar Paul versus State of Assam. A majority judgment. In this case, Justice Loku says once an application has been moved, the magistrate is duty bound to immediately dispose that off. And he cannot keep it pending and wait for them to file the charge sheet and then say that your right is defeated. And this case itself is very, very important in the sense that it says, even if he has not made an application, even an oral argument. Now this is the extent to which the court has gone. Now it was a case where somehow the lawyer had not filed the default application, bail application, had filed a regular bail application and the challan had not been filed, and the question arose whether in this case it was 90 days or 60 days. The argument was from the prosecution that this case up to 90 days. The court said, no, this is a case where it is punishable up to 10 years, but then what the minimum requirement of this provision is, it says minimum of 10 years. That means minimum punishment must be 10 years, not the maximum punishment should not be 10 years. So that when the matter was being heard during the course of the argument, he had raised the plea that he was also entitled to the plea, default bail. And court said, yes, he has, and you have not opposed it. You have not said that, no, he is not entitled. He has not made an application. So therefore, that is Rakesh Kumar Paul versus State of Assam is a beautiful judgment in which the court has not been very legalistic, that you must file an application. Even when you have made an oral submission before the court about your indefeasible right, you cannot defeat that right, and therefore that default bail aspect is very important. This is also talked about in another case called Union of India versus Nirala Yadav, 2014 9 SCC 459. Now these are two cases which I thought, and you must be very clear on what is default bail and when does the right accrue, and once an application has been moved, even thereafter, if the challan is filed, it will not defeat the right of the accused right will continue, because it will be counted on the day when he moved the application, and only condition that he has to satisfy, he was always prepared to give the bail and he was ready to give the bail. Now those are the twin conditions that are talked about in Rakesh Kumar Paul's case. This is another area that I just thought I'll take up. Another area that I just want to take up very quickly, because I think we are going to run short of time, is again the situation that I would like to talk about is anticipatory bail. 438. Now 438, we had earlier the two judgments that I would like you kindly to consider in this 438 situation is that is Sibia's case, which was a constitution bench judgment, and now that judgment has further been strengthened by another constitution bench judgment, that is Sushila Agarwal. Sushila Agarwal judgment is 2020 judgment. I think it was decided sometime in January 2020. We have Gurbakh Singh Sibia, which has been again reiterating the position. The court said anticipatory bail was a provision for the first time brought into the 1973 Act, because it was not existing in the earlier criminal procedure code. because by this time, when this 41st Law Commission report and 48th Law Commission report came in, gone to the lowest ebb, and people were filing malified cases against their rivals to win a march over them, and would, in order to bring them down in the society, bring cases and get cases registered against them, which were because of the political rivalries, and there were no substances in such cases. So a provision like anticipatory bail in 438 was introduced for the first time in 1973. And the court had to say, what is anticipatory bail? The court said, anticipatory bail, now this is very important that we must understand what is the concept. It is the difference between a regular bail and anticipatory bail is this. Is a pre-arrest direction given by the court. And this becomes operative when the person is arrested. Because arrest has to take place. But he has to be granted bail, that is why he has. And court said it's a misnomer to call it anticipatory bail. It is in anticipation of his arrest, but arrest, only when he is arrested, this right accrues. While as in regular bail, it is only when the arrest has taken place that he can go and ask for this relief. I hope you have understood the points the court says is a person in whose favor. I am quoting the judgment of Sushila Agarwal 2020 judgment by Constitution Bench of 5 judges, which reiterates CBR's case and says once anticipatory bail is granted, ordinarily it shall be up to the conclusion of the trial. But it does not take away the power of the Sessions Court or High Court when, in the circumstances of the case, they find that it has to be given up to a particular event taking place that was specifically stated there. Because earlier there was a set of cases where the court took the view which were smaller benches, and they took the view that once the summons or warrants are issued and appears before the court, the anticipatory bail, effect of the anticipatory bail should be over. Now he should apply for a regular bail. Now these cases, because of these cases and Matre's case, the court had to review all the cases that had come before it. But the point that I want to bring to your notice is, which you must, a person in whose favor a pre-arrest bail order is made under section 438 has to be arrested. However, once there is an order of pre-arrest bail, anticipatory bail, as and when he is arrested, he has to be released on bail. Otherwise, there is no distinction or difference between pre-arrest order under 438 and bail order under 438. And this is very important, which as a lawyer we must always know, and this sharp distinction is very clear and it is very conceptually to be understood. The difference is only the stage at which the bail order is passed. The bail order under 438 of the CRPC is prior to the arrest and in anticipation of his arrest, and bail order under section 437 and 439 is passed after a person is arrested. There is nothing in the language of 438 that the pre-arrest bail granted under 438 has to be a time bound. The position is very clear by virtue of the language. Now this is one aspect which needed clarification so that you people know what is the latest law. Latest law is the Supreme Court in Sushila Agarwal's case has reiterated the position in Gurbakh Singh Sibia and has overruled the cases which had gone contrary to the decision given in Gurcharan Singh Sibia. This is another area that I wanted to cover. I would like to cover another area which quickly. Now there are cancellation of bail. Now cancellation of bail can be two kinds. One is if a magistrate has granted bail, but you are aggrieved and you go to the higher court against the order of the bail. And you think that the decision of the magistrate is not in accordance with law and is perverse. Now that is decision on the merits of the case. The court will set aside the order of the magistrate by reappreciating the merits of the case. Then the second case is cancellation of a bail order because the accused has violated one of the conditions or more than one conditions of his bail order. Now those are cancellation of bail because of supervening circumstances. Those are 439(2), 437(5). Those are situations where a person's conduct subsequent to the grant of bail has to be taken into account. If an order has been passed by the magistrate and he has granted bail and you have not challenged that order may become final. And now you can only challenge that order subsequently only when you prove that he has abused his bail. His liberty has been abused, therefore that will be cancellation of bail for the violation of the terms or jumping the bail or trying to jump the bail. All those considerations will, I think that one of the very good cases on that is Sanjay Gandhi's case, a very good case if you look at how Justice Senior Chandrachud dealt with this whole subject. I think that's a very good judgment if you go on to that. Second issue that I would like to go is once a bail application is rejected, and can you go on filing one after the other bail applications? You may go on filing, they will all be dismissed. But as a lawyer, how should you advise your client? Or as a judge, how you should deal with the cases? Now you'll see that Chidambaram's case, Sanjay Chandra's case, in many times they went to the special court, dismissed. They went to the high court, dismissed. Then they again went to the special court, dismissed. They went to the high court, again dismissed. But if you look at this Sanjay Chandra's case, court said, now that the challan has been filed, charge sheet has been filed, this trial is going to take a longer time. And this person is 70 years of age and he is on medicine, he is on medication. Now there is a change of circumstance. So therefore the point that I am trying to make here is, if a bail has been rejected, you have to properly see whether there is a change of circumstances warranting again applying for the grant of bail. And if you can prove to the court that there is a change of circumstances on the basis of which you can apply for bail, again a fresh application can be made. There is no impediment in applying a fresh for grant of bail. Those are the situations where I think it is permissible for a person to go. I'll just like to only take you slightly to 436 and 437A. Now, 436A is a very important provision. Now, you must know that most of the cases, most of the people who are languishing in jail are people who are under trial. And many of them have spent more than half of the maximum punishment for those offenses. And some of them have even spent more time than what is the maximum time for the punishment for such offenses. How do you deal with these matters? Now, this was attended to by the legislature in 2005. In 2005, they created a provision in the CRPC by adding what we call as 436A. Now 436A, in spite of having been brought on the statute book which came into force from 23/6/2006, did not produce much desired results, and therefore a petition had to be moved before the Supreme Court. And that case is Bheem Singh versus Union of India. A very good case, you must read that case. And it was brought to the notice of the court that on the basis of the National Crime Record Bureau prison statistics in 2012, under trials total an amount of 2,54,857 who were languishing under trials in the Indian jails, while as the number of the convicts shows only 1,27,789. That means under trials are more than double than what are the convicts in the jails. And court found in many cases people had completed even the maximum punishment prescribed. And there were also foreign nationals who were languishing in jails. And therefore this provision Supreme Court monitored, required the sessions judge, chief judicial magistrate and the other functionaries to sit, find out from the Tihar jail and similarly other states how many people had spent more than half of the time or half of the time relating to the maximum punishment, and then those cases they were released on the basis of executing their personal bonds. Now this is what is actually a real justice that has happened because of this Bheem Singh's case versus Union of India, which was decided by Supreme Court on 4/9/2014. I think this case is still pending. Are very, very important directions which you must look at is implementation of 436A. There is a provision called 437A, which of course has been found. I think all of you must have found that it's a very strange that a person has to execute bail bond with sureties, or if whether he is convicted or acquitted by the trial court, and the case can go by appeal before the higher court. Now this has created a problem for the judges for implementation of this provision, because even if a person is acquitted, you're asking him to give a surety, execute a bail bond. I think the judges have found a way out by asking them to execute a personal bond, and this is how 437A is being, people are talking about having a relook at 437A. I just want only to cover very quickly. I have not covered cases which are coming under the special legislations, because those are cases which are PMLA. We have Companies Act, where they have this frauds, and there is a functionary created or a body created, SFIO, under they have the power under 212(6). There's a power relating to grant of bail. 45 of PMLA, which has said Nikesh Tarachand versus Union of India. It has been struck down, and it has become easier for the courts now to grant bail in PMLA's case. But then other provisions like Prevention of Corruption Act, Unlawful Activities Act, MACOCA, they have provisions similar to 45A. I think they are parametric provisions. Therefore, the courts can take the help of the Nikesh Tarachand versus Union of India and deal with cases of bail. But I think there is an amendment that has been now made in 2018, and that amendment to that provision 45(1) has been made to meet the Supreme Court's objections. But then they said, argument is that amendment can be made to a provision, but a provision which is struck down, which is not part of the statute, how can you make an amendment to that? You can only create a new provision, and when you create a new provision, it will be again liable to be challenged. Constitutional validity can be challenged. So that is what I thought, are some of the important areas which I wanted to cover basic issues that I wanted to cover in law bills. Thank you very much. I'll be very happy to answer some of the questions if you have.
Thank you very much, sir. I just request all the participants if they willing to ask any question to sir, just write down in chat box itself, or you can also mail us on our email ID about your question.
I thought I should give some time to people if they want to ask some questions.
Sir, मैं अजित कुमार.
I just request you to please write in chat box. Your question should be in chat box only.
You can give it to Mr. Jindal. He will read it out to me.
Yes, please. So there are some questions. An extreme.
You see, magistrate has no power to grant bail in murder cases. There's a very specific provision if it is punishable with death or life imprisonment. So therefore, I think merely because you go to the magistrate, you don't expect him. That's what one of the questions here says, that serious offenses, lower courts do not. I do not know lower court if you are saying magistrate's court. Sessions court, of course, will have the power, but then the question is, there may be 101 considerations, like if it's a case of a murder, there may be custodial interrogation necessary, there may be recovery of the weapons, there may be forensic evidence that may have to be sent, there may be a statement recording that has to take place. So therefore, it is only when slowly, gradually, these things happen and court is satisfied that you are not going to abuse your authority, this liberty, court will take all these factors into consideration. It is one thing, that is what, if you must have read, there was one Prof.Dr.B.T case, I think a very beautiful case on what the magistrate should do or should not do. They said it is one thing to have the power and it is another thing to exercise that power. Power you may have, but then you have to exercise it judiciously. And that power must be exercised judiciously. So therefore, the more the serious the offense, the more, I think those factors which I said are not exhaustive, but are only illustrative, have to be taken into account in the light of the peculiar circumstances of each case. And the judge has to decide whether this is a fit case for grant of bail or not grant of bail. Yes.
So there is one more question. Is so there is any difference in between bail and release?
You see, release can be of various kinds. Like a person can be discharged. A person can be like, when a person is discharged, a magistrate, you produce him before the magistrate. Magistrate does not find a prima facie case is made out. So the magistrate can discharge him. When acquitted, you see, you have to make a distinction between these terms. Release can also be bail. If you read 436, release, they are using the word release the person or you grant a bail to a person. I don't think there is much difference on that count. Phraseology doesn't change as long as the person was in custody and he is still undergoing investigation and then he has to undergo trial. I think it should not, nomenclature should not make the difference in the final consequence that has ensued in the case.
So there is one more question that
yes,
if police bail has not been granted by the police officials, then what will be the recourse? Because sometimes it was happen.
No, you see, ordinarily, in case of bailable offences, you should be able to get the bail from the police station itself. But sometimes it so happens you don't have a surety. So you are produced before the magistrate. Then magistrate has to be satisfied whether he is asking for a surety and how much amount security is asking. Those are questions which the magistrate has to decide. The bond, your personal bond, of what extent, and then the surety, what should be his solvency. And these, most of the, if you remember the cases of Hussain Ara Khatun 1, 2, 3, 4, what were those cases? Those were the cases of the people who were languishing in jail for years together merely because they were not able to arrange a surety. Or if they could arrange the surety, they could not arrange for the amount, security amount. That is why when the court said these people who shall be released on their personal bond, those are the proactive measures that the court had to take, because most of the people who are rotting as many of them are bailable offenses. They are people who have languished in jail. That is why this new provision had to be brought in 436 about the indigent persons. So Moti Ram was saying the same thing, though Moti Ram was dealing with the case of a non-bailable offense. But question, he said personal bond. How can I arrange if I am working? You said India is a diverse country, multilingual, multi-religious. You go to Kerala for a job, where will you find a second man who will stand as a surety for you? So India is a vast country and you cannot have a local surety. How will you arrange the local surety? If you have 7 days been in the custody and 7 days you are indigent, you should be released on your that is what
Now it's time to be going to be over. Sir, the closing remarks. Thank you, sir, for this inciting session, and thank you all the participants posting your queries. I hope we will again come with another session on the another topic with.
You send these questions to me. I'll come back.
Definitely, sir. Definitely, sir. We request all the participants to mail your queries or questions. We will.
Yes.
Thank you, Jinderji. You have conducted a very good seminar.
Thank you. Thank you.
Thank you. Thank you.
You can also see the recorded version of this webinar available on our media platform like YouTube, Facebook, and LinkedIn. Be safe, healthy. Thank you all. Thank you. Thank you, sir.
Send me a copy of that.
Definitely.
Thank you very much. Thanks. Thanks a lot.